Welcome to Spoken Injustice, where we put the criminal justice system in the dock. The first set of injustices the Spoken Injustice is focusing on are what they are more appropriately known as wrongful convictions. That is, when an innocent person is convicted of a crime they did not commit. The first point to note when dealing with wrongful conviction is that the true scale of wrongful convictions in England and Wales is unknown. This is due to the fact that most cases are not the subject of appeal or exposed by any other means. This is because, as shocking as it may appear to those who are not legally trained, factual innocence or guilt is not a factor that the Court of Appeal is concerned with when reviewing convictions brought to its attention. We will look at this in more details in our next video, so be sure to hit the notification bell so that you are notified when we release our next video. Here at Spoken Injustice, the first mission we have set for ourselves is to see whether, in the spirit of a social experiment, we could quantify the number of innocence claims. So how many people claim to have been convicted of a crime they did not commit? Let us know. We want to hear from you. It does not matter whether your conviction was obtained in the magistrate's court or in the Crown Court, if it occurred a few decades ago or recently, if you were imprisoned as a result of it or not. You can decide whether you want to tell your story here on this channel or privately in our hub at spokeninjustice.net. In the spirit of this social experiment, your presumption of innocence will be reinstated and we will be open to listen to your story afresh as you narrate it. At the risk of sounding predictable and repetitive, here at Spoken Injustice, we have a dream. Yes, we have a dream in which all innocent people who have been convicted of a crime they did not commit and have not yet managed to overturn their conviction, they can come together and form a strong, powerful community in which they can support each other whilst finding ways to be heard and their innocence recognized. A place where they can compare their story and their solutions to their individual cases, but most importantly, a place where they can keep their sanity, where they are not told that there is no smoke without fire, and that the position they find themselves is not as a result of something they must have done or something they have failed to do. So for decades, the painstaking process of uncovering and investigating miscarriages of justice has been left to a handful of sympathetic journalists, lawyers, campaigners and academics, some resorting to anonymity trickeries, see for example the secret barrister. It is time that we as victims take the lead. I'm sure you're all familiar with what has been dubbed the biggest scandal in the UK criminal justice system history. The Post Office scandal, also known as the Horizon scandal. By way of background, the Post Office scandal is an ongoing legal dispute between the Post Office and several of its former sub-postmasters who have claimed that the Post Office Horizon computer system was flawed and caused them to be wrongly convicted of financial irregularities. The exact number of sub-postmasters involved in this dispute is unclear, but it is estimated to be several hundreds. What made the post office postmasters vindicated was not a legal argument, though of course that in the end was fundamental, but it all started with their networking, their unity, their getting together. The power of their connection played a crucial role. By connecting one another, the sub-postmasters were able to come together and form a collective voice. They used their collective voice to raise awareness of the issues they were facing and push for change. Through social media platforms, they were able to reach a wider audience and bring attention to the scandal. By connecting with journalists, lawmakers, and other influential people, they were able to bring about an official investigation and ultimately help bring about a resolution to the dispute. The power of connection also allowed the sub-postmasters to support each other emotionally as they navigated the difficult and complex legal dispute. They were able to share their experiences, provide advice and guidance, and offer each other a sense of community and solidarity. This sense of community and support was crucial in helping them to maintain their resolve and fight for justice. Overall, the power of connection was a key factor in the outcome, and it highlights the importance of people coming together to make their voices heard and effect change. Conversely, the post office, as a private prosecutor with no external checks, succeeded in prosecuting innocent sub-postmasters on a regular basis for decades, because they told each sub-postmasters individually that the shortfalls in their system was an isolated incident. And in so doing, they relied on the certainty that the shame a prosecution will bring on each one of them would encourage their silence, and so the story continued. When one courageous individual took upon himself that there must have been more to the story, he used the power of social media to gather as many sub-postmasters as possible to understand more. And what he was faced was phenomenal, as each sub-postmaster realized that the hell they'd been through individually was the same hell that other hundreds of honest and hard-working sub-postmasters had been through. They gained a voice, truly amazing. So if you share our dream and believe in the power of one collective voice, consider subscribing to this channel and join our first and exclusive Miscarriage of Justice networking hub made by and for victims of the criminal justice system via our website at spokeninjustice.net. The bigger the participation, the greater opportunity we have to succeed. This channel is directed primarily to the community of England and Wales, and is not only for victims of miscarriages of justice or legal experts and practitioners. If you are an active citizen who want to make a difference and contribute to a fairer criminal justice system where the right person is prosecuted for the right offence and where no innocent people are caught into the mix, then this channel is for you too. You will realise that being in the wrong place at the wrong time or having previous encounters with the law is no longer necessary to become a victim of a miscarriage of justice. In fact, you could be accused of a crime whilst acting in the ordinary course of your duties, in your business, in your profession, in your job. That is exactly what happened to many post office sub-postmasters or to my husband. This is especially true today with the proliferation of private prosecutions, which do not afford adequate safeguards and scrutiny. We will cover this in more details in a future video. Other facts about wrongful convictions which are of interest are that in recent years, some of the changes in the law have been directed at addressing miscarriages of justice. However, many of these changes have not yielded, in fact, the expected results. For instance, the Criminal Appeal Act 1995 established the Criminal Cases Review Commission, or CCRC for short, which is a public body responsible for reviewing potential wrongful conviction and referring appropriate cases to the Court of Appeal for reconsideration. However, the CCRC has been the subject of recent criticism, having been accused of timidity in its dealing with the Court of Appeal and of being so cautious in its approach that has failed to refer a sufficient number of cases to the Court of Appeal. Similarly, hopes were raised by the Criminal Justice Act 1988, which established the right of a person who has been wrongfully convicted to receive compensation and made provision for the payment of this compensation. However, in 2014, the scheme eligibility was firmly requalified and limited to applicants who could show beyond reasonable doubt that they did not commit the offence. This has been highly criticised in view of the fundamental principle underpinning the right to a fair trial, that is the principle of the presumption of innocence, and particularly given that the factual innocence or guilt is not a factor taken into account by the Court of Appeal when overturning convictions. The issue of miscarriages of justice continue to be the subject of ongoing debate and discussion in the UK. Some of the current areas of debate include, for example, funding for legal representations. There is concern that people who have been wrongly convicted often struggle to secure adequate legal representation to challenge their convictions, particularly if they are from a disadvantaged background. The reliability of eyewitness testimony. Eyewitness testimony is often considered a key piece of evidence in criminal trials, but there is growing concern about its reliability and the risk of wrongful convictions based on mistaken eyewitness identification. And another one is the use of forensic evidence. There have been several high-profile cases in recent years in which faulty or unreliable forensic evidence has led to wrongful convictions. And there is ongoing debate about the need for improvements in the quality and reliability of forensic evidence used in criminal trials. Then there is the role of the police. There is concern about the risk of police misconduct, such as the suppression of evidence or the use of improper tactics, and the need for greater accountability and transparency in the investigation of crimes. Or the role of prosecution. Some call for greater accountability and transparency in the way cases are prosecuted, particularly in relation to appropriate disclosure of evidence that points away from guilt. This has been recently more prominent in cases involving sexual assault claims. And the proliferation in recent years of private prosecutions, which in our view are not subject to adequate scrutiny, that is also of particular concern. These are just a few of the areas of ongoing debate and discussion regarding the need for further reforms to address the issue of miscarriages of justice in the UK. Efforts made by various organisations, individuals and academics to address all these challenges in order to reduce the risk of wrongful convictions and also to improve the integrity of the criminal justice system have recently led to a creation of an all-party parliamentary group on miscarriages of justice. An all-party parliamentary group, or APPG for short, it's a group of members of parliament from all political parties who come together to discuss and raise awareness about a particular issue. Barry Sheerman MP, chair of the APPG on miscarriage of justice, recognised that miscarriages of justice have a truly devastating consequence for those who are convicted. It stated that it is vital the state does everything it can to prevent them from occurring them in the first place. And when miscarriages do happen, the state has to ensure there are quick and effective mechanisms in place to correct them. He concluded, currently those obligations aren't being met. The APPG on miscarriages of justice established the Westminster Commission on Miscarriages of Justice with a brief to investigate the ability of the criminal justice system to identify and rectify miscarriages of justice. The Select Committee has now concluded its work and published its report called In the Interest of Justice. In response to this report last summer in August 2022, the Law Commission of England and Wales announced that it will launch a wide-ranging review of the laws governing appeals for criminal cases in England and Wales. The review of the Law Commission will focus primarily on whether the test of real possibility used by the CCRC to refer the cases to the Court of Appeal is the right test, and whether the requirement to show that a jury's verdict is unsafe makes it too difficult for the Court of Appeal to correct miscarriages of justice. We will cover this more in details in our next video, so be sure to hit the notification bell to be alerted when we release our next video. We believe there has never been a better time to escalate these concerns and, most importantly, to take matters into our own hands. We want to highlight what a wrongful conviction does to victims and the ripple effects it has on their families, friends, and the community as a whole. Our plan here at Spoken in Justice is not for us to release videos where we talk to you about what we think about miscarriage of justice. Our plan here is a big one, but for that we need your help. The bigger the channel it becomes, the more chances we have to invite the real experts in this area. Who are the experts? Well, to start with, we want to invite the victim of miscarriages of justice themselves. We want them to tell us the devastation they have experienced, the ripple effect on their loved ones, and how their lives have changed and changed forever. Then we want to, of course, invite the practitioners, those who have witnessed what their clients have gone through and who can elucidate us on what went wrong from a technical point of view so that we can piece the picture in its entirety. And finally, those who have taken the time to analyse, such as academics or charities, so that we can gain an insight into this complex problem and gain an accurate and deep understanding of it. We post videos weekly. Don't forget to hit the notification bell to be reminded when our next video is out, and consider subscribing to help us grow this channel so that we can invite prominent experts engaged in this debate to keep us up to date and to elucidate some of the most problematic issues involved. And of course, join our networking hub at spokeninjustice.net to have your say as to the future content of this channel. We look forward to usher you as we sit and rise in this unique trial.